Yeah.
Sounds good. All right, you are Larry Fitzgerald Williams. And Mr. Williams, in cause number 25 DCCR 0985, is charged with capital murder. And Mr. Cashion has filed a motion asking that I reduce bond. We were here either last week or the week before. Reset this case today to give everybody some time to get prepared on that motion. And Mr. Cashion, do you intend to call your client?
No, ma'am.
Okay, you may call your first witness.
Okay, so before I do that, Your Honor, I know some of these proceedings are streaming, and one of my witnesses is going to testify. Can she refrain from using her specific address?
Absolutely. I don't typically require any, just Jefferson County is fine.
Jefferson County, yes.
Yes, sir.
Yes,
Absolutely.
sir.
We don't need specific addresses ever,
That's
or very rarely from
Okay.
especially a witness.
Okay. All right. I'd like to call Angel Anderson.
Ms. Anderson and Mr. Williams, if you'll just kind of step around closer to Mr. Cashion, kind of right there. You're good right there, sir. And maybe you can come right up here in the front, please. Good morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may proceed.
Thank you. And will you please state your name for the record?
Angel Anderson.
Ms. Anderson, where do you currently reside?
Beaumont, Texas.
Okay. And how long have you lived in Beaumont, Texas?
For 43 years.
And do you know the gentleman to your left?
Yes.
What is his name? And
Ma'am, can you speak up so that I need to hear you and the court reporter needs to hear you as well, please? Thank you.
what is your relationship to Mr. Williams?
That's my brother.
So you've known him all of your life.
All my life.
And does he currently reside here in Beaumont?
Yes.
Okay. Are you currently employed?
Yes.
And what do you do, ma'am?
I have a business.
What kind of business?
I have a hair salon.
Okay. And that's here in Beaumont?
Yes.
Okay. And how long have you been the owner of that business?
For 6 years.
Okay. And so, Mr. Williams, prior to him being arrested, was he working?
Yes.
And how long had he been working? What had he been doing? What type of work?
Landscaping.
Okay. And he, have you ever, do you know what a bond process is?
Yes, sir.
And you know what a bond consists of?
Yes.
And you have to go to a bondsman, correct?
Yes, sir.
And the bondsman wants to be assured of what things?
A co-signer, financial,
And
and
collateral. Okay. And do you and your family and friends have enough money to post a bond like within an amount of maybe like $50,000?
Yes, sir.
And
Hold up, the family says they can post up to $50,000, but the current bond is $10 million. That's not just high, that's astronomical. For context, bonds at that level are usually reserved for severe flight risks or the most violent charges. So yeah, this motion to reduce bond, it's an uphill battle.
presently he has a bond that's approximately $10 million. Is that right?
Yes, sir.
And have you all attempted to make that $10 million bond?
No, sir.
And the $10 million bond, that was set by a magistrate like early on in this process.
Yes, sir.
And also his other bond was aggravated assault case was raised. Is that correct?
Yes, sir.
From what to what? $200,000. Okay, so he has approximately $10,100,000 worth of bond. Okay, and if the judge sees fit to place his bond like at maybe $50,000, do you have family, friends who put up the property like collateral as well as money in order to secure the bond?
Yes.
Would you be willing to co-sign on the bond?
Yes.
Do you have other family members that would be willing to co-sign on the bond?
Yes.
Have you been in touch with the bondman, and do you know of a bondman that would be willing to go along with the bond for you?
Yes, it's in good standings with his bond.
I'm sorry, I can't hear you.
Yes, yes, ma'am. He's in good standings with his bond he had.
Okay, so
I still didn't understand what you said at the end.
He in good standings with the.
Oh, he's in good standing. Okay.
okay. have you ever known Larry not to appear in court?
No, sir.
And he has, on the other bond that he had for the aggravated assault, did he ever fail, to your knowledge, to come to court?
No, sir.
He always came to
Yes.
court every time, on time. There was never any problem with him showing up in court.
No, sir. There's no problem.
All right. And I passed the witness.
All right, thank you, Mr. Cashion. Mr. Smith, any questions of this witness? Thank you, ma'am. You can go back and have a seat. Any other witnesses, Mr. Cashion?
No, ma'am, but Your Honor, I would like to point out that the family members in the courtroom
Yes,
that
sir.
are of adult age, Tanisha Williams, his daughter, who is present in the courtroom, she would say the same thing that Ms. Anderson just said, as well as his daughter, Laredia Clay, who is also an adult, and she would say the same things, and we can confirm with what Ms. Angel just now said.
Thank you.
Presently, his bond, which I feel is
Mr. Williams, you can step back around, sir.
Presently, his bond, which I feel was emotionally set at $10 million. I think that is very excessive and is very punitive. And Mr. Williams, although he has had some issues with the courts and the judicial system, he has never ever failed to appear in court. And I think that because of, I think that his prior attendance in court, his prior taking care of all of his court business, shows that he is not ready to flee, he's not ready to run, that he will come to court and face the charges and face whatever the court requires of him. A monitor would be sufficient to maintain his location, like with the GPS. He does need to work, so I would not like to request that he be placed under house arrest, but I think he should be able to have maybe a monitor or maybe some curfew hours as opposed to a $10 million bond. I think a reasonable bond for a case like this should be about $50,000, and I would like to request that the court set his bond at $50,000.
The defense plays their strongest card, loyalty and reliability. They're framing Williams as a man who always shows up, not someone on the run. And to sweeten it, they propose GPS monitoring instead of an outrageous bond. But will that argument hold up against what comes next?
$1,000.
Okay. Mr. Smith?
Judge, the state is opposed to a reduction in bond. This capital murder is based on the fact that we were coming up for trial. The murder of the victim, who was also the victim in the aggravated assault, occurred very shortly before that was actually going to be called for trial. And the fact that he fled after committing this murder to Houston and had to be located in Houston shows that he is likely to run if given a bond. Family of the victim is also in fear for their lives should he get out of jail. And we'll be ready to proceed to trial as soon as Mr. Cashion is up and ready.
Your Honor, in regards to what
Here's where the tension spikes. The prosecutor drops a bombshell. He claims the murder victim was the same person as the earlier assault victim, and that Williams fled to Houston afterward. That's a major credibility hit to the defense's "he won't flee" argument.
Mr. Smith just said, Mr. Williams, when he was located in Houston, was on his way to my office. And that's the reason he was in and around the Houston area, because he was coming to my office to consult with me because he had heard on the news reports about this alleged murder, and so he was coming to talk to me, and he was not in the process of fleeing, but he was in the process of coming to consult with me about his situation. So I think that by alluding to the fact that he was arrested in Houston is like kind of a stretch, because he was attempting to meet me at the office.
All right, so obviously this case is the date of this case precedes any modifications that happened in our legislation this last cycle that have come into law as of yesterday. One of those is actually that it is appropriate, and if someone is out on a bond for a felony offense and the allegations are that they commit another felony offense, to have no bond, which is something that is more strict instead of more lenient with regard to bonds. I believe the fact that Mr. Williams has come to court when required obviously is nice and great, but the fact that the allegations are that, and they're allegations, he hasn't been found guilty, but I am entitled to take into consideration the underlying facts of the case. And so based on the offense that he was charged with initially, the aggravated assault, based on the fact that this new allegation is that the victim or the complaining witness in that case is now the victim in this alleged case, I do not find that it would be in the best interest of our community to grant the motion, and I am going to deny that.
And there it is, the judge denies the motion. Legally, this makes sense. Committing another felony while out on bond almost guarantees no leniency. But it's also a sobering reminder. The bond system isn't about punishment, it's about risk. And in this case, the court sees plenty of it.
Motion to reduce bond. We will get the case moving as quickly as possible. Get with Mr. Smith, and again, just like we talked about before with regard to any issues, just let me know if there's any issues with regard to discovery, and I'll set it for an announcement in about 30 days, give y'all some time to see where you are. And then again, once it's ready for trial, if it's going to be a trial, we'll get that done as quickly as we can. All right, you can go back with the bailiff.